So let's talk today a little bit about the differences between a mortgage and a deed of trust. Let's talk locally. So certainly in Massachusetts and New Hampshire, here we have mortgages. These are essentially two-party agreements. We have a lender and we have a borrower. The borrower may be referred to as the mortgagor. The lender may be referred to as the mortgagee. A deed of trust is a three-party agreement. There are three parties. There is the borrower, who is the trustor. There is the lender, which is the beneficiary. And then there is a neutral third party, which is typically a title company or an escrow company. It could be a bank. It could also be an attorney. A deed of trust state or a deed of trust process involves non-judicial foreclosure. Banks love non-judicial foreclosure for obvious reasons. If the borrower is in default, the lender wants to foreclose in the most expedient, cost-effective, cost-beneficial way possible, and a deed of trust would certainly be the vehicle for that. I've heard people say, well, we use mortgages on the East Coast, we use deeds of trust on the West Coast, but in fact, there are even states in the country that will give the lender the option as to whether to utilize a mortgage or a deed of trust. But if somebody talks about a deed of trust, or they're getting a deed of trust, or they're signing a deed of trust, or they have questions about it, it probably just means that they are getting a mortgage to purchase a home in a country that utilizes that framework.